Hello everybody, my name is Lauren Gearhart, and for this week I'm going to be presenting my written assessment that we did last week. To begin, I'd like to define what jurisprudence is. So jurisprudence refers to the theory or philosophy of law. It provides intellectual foundation for how laws are created, interpreted, and applied. Scholars use jurisprudence to examine statutes, analyze court decisions, and understand how lawyers argue cases. What makes jurisprudence so important is that the different schools of legal philosophy define justice differently. And these differences shape everything from courtroom procedures to rights to individuals. And by studying these schools of thought, such as I presented in my paper, natural law, legal positivism, legal realism, and pragmatism, we can understand why the American legal system functions the way it does. So, criminal law and natural philosophy. Criminal law in the United States is grounded heavily in natural law, which emphasizes inherent human rights and moral limits on governmental power. Because the state has authority to arrest, prosecute, and imprison individuals, there is a moral obligation to safeguard people from governmental abuse. This is why constitutional protections such as the Fourth Amendment against unreasonable searches, the Fifth Amendment against self-incrimination, and the Sixth Amendment right to counsel are so central. Procedures like the Miranda rights and preliminary hearings and the standard of proof being beyond a reasonable doubt are not just legal rules, but they're reflections of this philosophy. On the other hand, civil law relies more on legal realism and pragmatism. Civil cases handle disputes between private parties, and the emphasis is on resolving conflicts rather than finding who's right or wrong. This is where pragmatic thinkers become influential. So approaches emphasizing economic reasoning, real-world outcomes, and data instead of rigid legal formalism is important. We see this reflected in tools like summary judgments and case management practices, all designed to make litigation more practical and efficient. And civil procedure is less about protecting defendants from the state and more about finding workable, reasonable solutions for private disputes. So, judges serve as a link between legal theory and legal practice. Even though judges don't openly advocate for specific philosophies, their decisions inherently reflect their jurisprudential preferences. So, it suggests that judges' personal experiences, values, and interpretations shape their ruling. And in common law systems like ours, judicial discretion is powerful, influencing everything from interpretations of statutory language, for example. So, attorneys also strategically rely on jurisprudence while building cases. Criminal defense lawyers often lean on natural law and constitutional principles to argue to the state acting unfairly. In civil cases, attorneys take a more pragmatic approach, adjusting their strategies based on preferences or what will move the case forward efficiently. On the appellate court level, jurisprudence is a little bit more explicit. They often begin with legal positivism, examining statutory texts closely to interpret procedural concerns. But when statutes are kind of unclear, they turn to pragmatic reasoning. They can also use experimental or empirical jurisprudence. It shapes every layer of the legal system, criminal law reflecting natural, and civil more pragmatic. Thank you.